Thank you very much. Can I welcome everyone to the Justice Committee's 23rd meeting of 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Item 1, Declaration of Interest. Our first item is to invite Elaine Murray and John Pentland to declare any interest relevant to the remit of the committee. Elaine.
The only thing I can think of is I am a member of Unite the Union. I feel it necessary to tell people that, but I don't think of it's necessarily on
perhaps you're in the wrong place today. You should be somewhere else. John Pentland, do you have anything you wish to declare?
Convener, I have no relevant interest to declare.
Thank you very much. Item 2, we now move on. It's a choice of a new Deputy Convener. The Parliament has resolved that Deputy Convener should come from the Scottish Labour Party. Can I therefore invite nominations for the position of Deputy Convener? Sandra.
I nominate Elaine Murray, MSP.
Thank you very much. There are no other nominations. One nomination has been received. I therefore ask the committee to agree that Elaine Murray be chosen as Deputy Convener of the Justice Committee. Try to look pleased. Make her feel at home. Thank you. Thank you. Item 3. Anti-Social Behaviour, Crime and Policing Bill, UK Parliament legislation. We're moving on to consideration of this LCM. And I welcome the meeting Kenny MacAskill, Cabinet Secretary for Justice, Jim Wilson, Policy Officer from the Criminal Law and Licensing Division of the Scottish Government, and Peter Jamieson, Policy Manager from the Police Division of the Scottish Government. And can I invite the Cabinet Secretary to make a brief opening statement before I open up questions to members? Get your pencils ready, members. Cabinet Secretary.
Thank you. The draft legislative consent motion seeks approval for the United Kingdom Parliament to apply the relevant provisions of the Anti-Social Behaviour Crime and Policing Bill. Most of the bill does not extend to Scotland. The parts of the bill that extend to the devolved areas relate to the abolition of the Police Negotiating Board, the PNB, dangerous dogs and witness protection law. In relation to PNB, we've agreed to its abolition, and we intend to establish a separate police negotiating board for Scotland through the Criminal Justice Bill, which was introduced prior to summer recess. The PNB provides a forum in which representatives of police officers and those who manage and fund police forces can consider questions relating to police hours of duty, leave, pay and allowances, pensions, clothing and equipment. It operates on a UK basis, and the Home Secretary, Scottish Ministers and the Department of Justice in Northern Ireland are required to consult it before making regulations on relevant matters. Following the recommendations of the Windsor Review of Police Remuneration and Conditions in England and Wales, the Home Office intends to replace the UK PNB with a police remuneration review body for England and Wales. The Scottish Government has published a consultation paper in July. The paper seeks views on the detailed arrangements for the functions, membership and procedures of PNBS. The consultation closes on Friday, 27 September 2013, and I can reassure members that we will carefully consider all responses to our consultation and consider the implementation and commencement of both bills as we move forward. In relation to witness protection, at present the offer of protected status, i.e. witness protection, can only be made to those listed in the Serious Organised Crime and Police Act 2005. This includes witnesses, informants, judges, jurors and others working within the criminal justice system. While covering the majority of those at risk, who tend to be witnesses, we are aware concerns have been raised about the protection of vulnerable individuals whose lives may be at risk but who do not fall within the scope of the 2005 Act. And for example, potential victims of forced marriage or other honour-based violence who may be identified before any crime is committed. The purpose of the proposed amendment is that it would not alter the list set out in the 2005 Act, but would rather give the Chief Constable the discretion on a case-by-case basis to make protection arrangements for individuals whose lives are at risk but who are not currently covered. Finally, on dangerous dogs, the bill contains provisions that will explicitly include attacks on assistance dogs as an aggravated offence under the Dangerous Dogs Act 1991. The bill also ensures the courts assess the character of the owner in determining whether a dog poses a danger to public safety. We think this is a sensible response to the 2012 court judgment, which called into question the existing powers of the courts in this area. And we believe the extension of the relevant provisions to Scotland can be justified on the basis that it's a sensible and appropriate step to ensure the effective and consistent implementation of various policy changes that affect England, Wales and Scotland. So I hope the committee will share our view that we consider it helpful for these changes to be made within the UK Bill as an effective and efficient use of the LCM procedure, and I therefore ask the committee to support the legislative consent motion, and I'm happy to take any questions.
Thank you very much, Cabinet Secretary. Now, I don't know if you prefer me to take it this way, Committee, but I was going to just take the 3 categories and let you ask questions in categories. So, Police Negotiating Board, followed by the dangerous dogs, followed by witness protection, if that's helpful. So, who wants to come in on Police Negotiating Board, first of all? John Finney, and then, John Finney, then John Pentland, then Roddy. Right.
Thank you, Convener. Morning, Cabinet Secretary. Cabinet Secretary, I commend the Scottish Government's approach of having a PNB Scotland, is something I proposed many years ago. Can I ask if the Chief Officer ranks are going to be included in this?
We're discussing with SCOPOSA. Our preference would be that they do come in, and that's a matter that they're currently mulling over.
Is there any indication? I think it would be preferable if all Scottish police officers were covered by the one.
I think it would. I think they have matters to sign off, and it'd be wrong for me. I think they have to answer for themselves, but certainly we're very hopeful that they'll come on board, because I think I share your views that it would be better that all ranks are covered.
Okay, thank you.
It's John Pentland, please.
Morning, Cabinet Secretary. Cabinet Secretary, I was wondering whether yourself or the Scottish Government ever consider following the UK's review of the SMB.
Well, we didn't agree with the Windsor review. My view on this, Mr Pentland, is we've always taken on board the views of those involved in police, whether it's the management side or those representing the staff. They are uniform in saying that they wish a police negotiating board, and it's for that reason that we are establishing one in Scotland. This is the wish and desire of both sides, indeed all sides of the table represented, and we are delighted to go down that route.
And obviously, if there can be some reassurance that the establishment of the new Scottish PNB, if it does happen, and the old one going out, can we have a reassurance that the transitional period will be smooth and
Oh yes, I mean that's fundamental. We have already established a standing committee, so there's one already up and running, although not formally constituted by the statutory basis. But we do hope that the legislative basis here will dovetail, but there is also a fallback position of continuing under the existing PNB powers, so I can give you an assurance that matters are capable of being dealt with.
And finally, Cabinet Secretary, on financial implications, if we do establish a new Scottish PNB, we're saying that the likely cost would be cost neutral. Are we quite sure that that will be the case, and or is there perhaps it might rise or whatever?
I would have thought so. I think there will be matters that will have to be addressed on a distinctive basis, and that's raised with us by the Scottish Police Federation, as doubtless Mr Finney knows. Most of that's about access to information, and that can be provided through other bodies. So we do believe it's cost neutral, but any cost would be fairly minor. And as I say, I think we take the view that when management and indeed the workforce representatives are clear that this is the structure that they want, then unless there's something glaring, we would not wish to go in that direction. And certainly I think nobody in Scotland on either side of the table wishes to follow the proposal of the United Kingdom Government.
Thank you. Roderick.
Just following on briefly on the financial point, at the moment we're contributing to the Home Office about 10%, £50,000 annually. Are you confident that the cost of the replacement body will be of that level?
Yes, I think it'd be fair to say that the body down south is pretty substantial, with the number of people would struggle to fit into this room that have to sit around the table. So I think it will decrease because of this proportionate size of Scotland. I think the amount of money set aside will provide there. The concerns, I think the very minor concerns that, for example, the SPF raised to us, and Mr Finney will probably be aware of this, is more access to information in terms of how they can judge what parity is and access to statistical information. But that can be provided through ONS and through other matters. So we're quite confident that the cost structure in a lighter, smaller body, but still significant to ensure that all parties are represented around the table, can be met within the current envelope, and indeed the desire for any additional resources or matters that I think can be provided by ourselves or other bodies.
Thank you.
Thank you very much. I'll move on to now the amendments to the Dangerous Dogs Act. Can I have indications? Elaine, followed by Roderick, and then Sandra White.
Thank you, Convener. I've had a couple of questions on the Dangerous Dogs Act. The first
You
on...
don't need to put a marker down. You
Right.
just get to ask questions.
Okay. The first one is on the issue brought up by Guide Dogs Scotland, that the definition of an assistance dog, as in the Equality Act of 2010, is a bit broad, and they suggest in particular that it's based on that in EC regulation, focusing on saying that it'll be, I think particularly issues about that the dog should be trained by accredited member organisations of the International Guide Dog Federation or Assistance Dogs International. I just wondered if you had a view on that definition.
Well, we're aware of concerns, the points raised by Guide Dogs Scotland. We're in touch with DEFRA officials who are leading on this, and our understanding is that guidance on what exactly is and what is exactly not to be an assistance dog will be provided. So we are confident this amendment will provide sufficient clarity, and indeed will get the benefits of the advice from those who are currently negotiating and discussing matters with Guide Dog Scotland. So we're conscious of it and negotiating with, or negotiating is not the word, but liaising with DEFRA.
The other point is on the SSPCA's view. I mean, the SSPCA, as you know, are not keen on the legislation at all, but they are in favour of the ability to assess the character of the owner as well as just the character of the dog, and in cases of exempted dogs or dogs of banned breeds. Would you favour their suggestion that the scheme could be redrawn so that an exempted dog could actually be rehomed with somebody else of a more appropriate character to maybe care for that dog, rather than necessarily being destroyed?
Well, we think that the change is necessary really because of a court case that occurred actually south of the border rather than here. But clearly, although it wouldn't necessarily be binding on a court here, it would be a matter that they would doubtless look at. So it seems to us looking at the character of the owner as something that should be available, should be taken into account, and it would seem to me that that would follow the point that made. If the dog is not necessarily the issue but perhaps the nature of the owner, then hopefully we could work out that this would provide the flexibility. And it does seem to me that this is about flexibility. The current legislation that we drafted, which was, I think appropriate at the time, was simply to look at the dog per se. The court case makes it quite clear that the nature of the owner and their activities should be looked at. That seems to us perhaps a direction in which we should go. So I think this would meet the concerns of the SSPCA and I think provide the appropriate flexibility for the court at the time.
Well, of course, Scotland's ahead of the game with the Control of Dogs Act, which, of course, is the deed, not the breed, and looks at responsible ownership. And perhaps down south we could pay a little bit of attention to that legislation, introduced first by Alec Neil and then pursued by myself. But the bulk was done by Alec Neil, to commend him for that. Roderick.
Is there any kind of research that's been done either in Scotland or kind of for that matter in the rest of the UK as to the likely numbers of additional dogs that will be destroyed by taking into account the character of the owner?
I think very little, but Jim, you're able to...
Yeah, I'll just come in on that point. I mean, in terms of statistics that are gathered by the Scottish Government, we don't actually hold any statistics in relation to destruction of dogs. That said, I mean, it may be helpful to advise members that in relation to banned breeds of dog, there have actually been 9 applications in the past 10 years. Now, these are Section 1 banned dogs, and the courts have decided that these dogs in question did not present a risk to public safety, and as long as the dog owner or keeper ensured that certain strict conditions were actually met, then they were allowed to actually retain the dog. But the point, I presume you're picking up on the SSPCA's comments in relation to destruction, which I think is a very important point, and it will be important to actually measure the impact of these provisions going forward. We certainly have plans to liaise with Police Scotland, National Dog Warden Association, and indeed I intend to speak to Mike Flynn at the next cross-party group on animal welfare, which I think will be held 2 weeks today. So take on board that we don't actually have statistics in relation to destruction. I think a key point to make is that the benefits of actually having the Control of Dogs 2010 Act is that it's all about preventing dog attacks from happening in the first place. The reason that legislation was brought about was because of I think it was a 160% increase over an 8-year period. So something had to be done. We have conducted some high-level research in relation to the number of dog control notices that have been served in Scotland during the first 2 years. Figures supplied by councils would suggest that 235 notices have been served, and we are aware of a prosecution that occurred in the Shetland Islands. So although it's relatively early in terms of looking at the impact of the Control of Dogs legislation, I do think that the Act has got off to a steady start. Sandra.
Thank you very much, Convener. I just wanted to pick up on some of the information we've had from Guide Dogs Scotland and wondered if you'd consider the information you've given them and their concerns about the Equality Act and the interpretation of it. They mention in it that attacks on guide dogs are at an all-time high, and from 2011 to 2013, something like 2 a month. I just wondered, when you were speaking to Guide Dogs Scotland, was consideration given to this under the Equality Act and the interpretation you make of it?
Yeah, just again on the suggested amendment, it's my understanding that what Guide Dogs Scotland were actually asking for would be an amendment that would actually require the Secretary of State to designate dog training organisations. And we don't think that that's actually needed, but as the Cabinet Secretary has already advised, that we do plan to ensure that there will be guidance. Now, as we know, dangerous dogs has actually devolved. However, if there was a case for, given it's a UK Parliament bill, if there was a case for UK-wide guidance, then we will ensure that Scottish viewpoints are taken into account when the guidance has been formulated and worked up.
Thank you, Chair.
While you're at it and you're liaising with Westminster over this, are they in any way, just as a kind of postscript, this considering bringing forward something similar to the Control of Dogs Scotland Act, which, as you rightly says, intervenes early and looks at attacks across the board, because, as we know, there are huge issues about being able to define what is a breed that is in fact prohibited?
Yep. I mean, I did recently attend, it was a dangerous dog seminar in London, and the opening remarks were actually delivered by the chair of the EFRA committee, and in her view that she very much liked the model that had been introduced in Scotland, so that we now have a dog control notice regime, and had suggested to UK ministers that there should be a similar model adopted for England as well. Now, so far, I've not seen any indications that they will actually have a similar scheme. The approach that actually has been taken would appear to actually wrap up dog control issues as part of the Anti-Social-Behaviour order, which, I don't have any strong views on that, but it would appear that there is no signs of any movement to follow or replicate the provisions that you put forward to Parliament.
Rather a pity. But there we are. We now move on to witness protection, which is the third segment. John Finney, followed by Colin Keir.
Thank you, Convener. Cabinet Secretary, I'd like to ask you about a concern that's been voiced by the Police Scotland regarding the possibility that this would facilitate people involved in criminal feuds, and given the getting protection. First of all, commend the cross-jurisdiction application of this. I think that's desirable and very positive. But the protected person status to someone involved in a criminal feud, the requirement for them to be maintained at the same level, is there any way that can be addressed? Clearly we want people protected.
Well, I think this matter would have to be signed off by the Chief Constable. I'm sure if somebody was felt by the Chief Constable to perhaps be under threat, but not necessarily be somebody who had a lifestyle that would be conducive or was likely to change, I doubt they would be prepared to sign it off. We obviously have, as you'll know, Osmond warnings and other matters that are dealt with by the police. So I think that the changes here in the current system do ensure that ultimately the police have a say and do not require to give any support or assistance beyond what should be given to every citizen in terms of provision of public safety. So we don't have any concerns there. I trust the common sense of the Chief Constable.
That was your question. Right. I'll let you in first next then, Colin. He pinched it. But you didn't know you were pinching it, but you did. Alison, followed by Sandra.
Thank you. I mean, I think the extension is to be welcomed, particularly in relation to forced marriages, perhaps, and honour-based violence. So it is a good thing. I note in the papers accompanying the LCM, when you're discussing the financial implications of this, you say that obviously it's a demand-led area, it's difficult to ascertain. But you do say that these new powers are discretionary. Can I just check that that doesn't put it on a different footing from the other people that are eligible to being covered by the Witness Protection Scheme? It's all the one thing. Thank you very much.
Thank you for that. Sandra White.
Thank you very much, Convener. And I also welcome the extension to forced marriages and obviously honours-based marriage. I think it's a very good step forward and certainly been welcomed by Women's Aid and others as well. I'm minded of some of the comments from Victim Support Scotland, and basically saying that perhaps this bill could be strengthened, make it a more robust framework with more information and more support. Just to ask the Cabinet Secretary, do you feel the bill as it stands just now is adequate, or could it move more forward as Victim Support has suggested?
I think the legislative basis is there. I think the appropriate guidance is there. I think a lot of VSS's concerns relate to the practical handling of matters. I don't think that therefore requires legislation. That requires to ensure that it's implemented appropriately. And it would also seem to me that we're dealing with not a large number of cases, and they can be very varied. It can be somebody who perhaps does have some past record of criminality, albeit not of the matter that is causing, I think, understandable concerns raised by Mr Finney, but has to be relocated. There could be people who are entirely innocent. There can be people who are relocated within Scotland. There can be people relocated within the United Kingdom. And there can be people relocated out with the United Kingdom because we've signed off relationships with other countries. So I think this has to be left almost on an individual case-by-case basis. It might be as things develop and as matters arise, but certainly in Scotland at the moment it's very limited. And I do think it's... I don't think the devil's in the legislation here. I think the difficulty is in the implementation. And I think the points made by VSS are well made, and that's where what we have to do is to ensure that those who are looking after the interests of witnesses are in consultation with those who are looking after their safety and their relocation. And I can certainly give you an assurance that we will be feeding back to the Chief Constable, because ultimately this is dealt with as a police matter, how we deal with that.
Thank you, Chair. That's fine.
Now here come the fatal last words. I don't see anybody else wanting to ask any questions. Usually that's when we have a little flurry. We're not having one, thank you. So can I just thank you very much for your attendance. That's us concluded that part. Can I say to the committee that our next meeting on 17th September will hear from the Lord President and the Minister for Community Safety and Legal Affairs on the Tribunals Bill. We also at that date will consider this LCM. We heard in evidence today and we have to sign off our report then. Right? Now I move on to the next item of business, which is... I went in there too fast. And I'll suspend for a couple of minutes to allow the nameplates to be changed. I moved on to... Thank you very much. This is the next item, which is our second evidence session on the Tribunal of Scotland Bill. Now, welcome to the meeting Adrian Ward, Convener of the Law Society's Mental Health and Disability Subcommittee, Richard Henderson, Convener of the Law Society of Scotland's Administrative Justice Working Party, Jonathan Mitchell, QC, Faculty of Advocates, and Alan Gamble, a judge in the Upper Tribunal Administrative Appeals Chamber sitting in Scotland. Can I thank you all for your written submissions? I understand, Mr Henderson, that you'll be able to speak to both the Law Societies and the Scottish Committee of the AGTC's submission.
Yes.
Good, because I made a mistake last week with Mr. Wright and wouldn't want to repeat it. And what I don't know if you've all been here before, but you simply, the members will indicate they want to ask questions. If you just indicate to the chair and myself if you want to respond, and your microphone will come on automatically when I call you. Thank you very much. Questions, please, committee. Elaine?
It's for the Law Society. You indicate some concerns about the fact that the bill should identify the characteristics which distinguish tribunals from courts. And indeed, Citizens' Advice last week expressed similar concerns, and they have in their evidence proposed specific amendments to the bill which would actually entrench some of those characteristics in the bill. And these are based on the Tribunal Courts and Enforcement Act 2007. Just wondered if you agreed that an amendment of that sort should be put forward.
Mr. Henderson.
Well, I lead off on this one then. The issue about whether you define a tribunal is really related to the relationship of courts and tribunals, and in fact whether we have a civil justice system in this country and what the components of that are. If we have a court, we have a civil courts reform process in train. We have a tribunal reform process in train. Part of the civil courts reform process, as I recollect it anyway, involved talking about a third tier of judiciary, and that third tier might, as it were, leach across, that's the wrong word, but wash across into a tribunal structure. So you've got a linkage between these two components of a civil justice system. Now, the tribunal system we have just now is fragmented. It's comprised of subject-related bodies, and they're nearly all different. Their founding legislation is different. The substantive law that they administer is different. There are common characteristics of what makes a tribunal. Whether those common characteristics stretch across into what is a court is another matter. But tribunals were established originally because they were to be less formal than courts. They were to be user-friendly. There were to be places in which, in effect, justice was going to be determined without the necessity of appearance with lawyers. So the nature of the proceedings is going to be quite different to what is generally the case in courts. Now, if what you're doing is creating a new tribunal, and we know in other parts of the forest we're talking about what are you going to do with housing? Is it going to be some matter that goes to a tribunal, or is it going to be a matter that goes to a court? What are the characteristics that you're looking for in the adjudication process? Until you've worked out what you can buy, as it were, what these different components are, then you are to some extent dealing with things in a slightly anarchic fashion. You couldn't have had a civil justice review 5 years ago, because at that stage we weren't talking in terms of the kind of reform processes that we're talking about now. It's only when you get some way down the road to reform courts, to reform tribunals, that you then begin also to think about what are the other components of a civil justice system. Notably, ombudsman, complaint systems, all of these together make up what you would call the civil justice system. And if you're going to reform in different areas, sooner or later you ask yourself, what is the linkage between these different areas? And if you're going to ask that question, sooner or later you ask yourself, what is a tribunal? And that's what takes you into the need to define it.
Does somebody else wish to comment? Yes, Mr. Mitchell.
Yes, can I make 2 points? The first is that I think we've got to constantly bear in mind with this bill that it is not in truth about Scottish tribunals as a whole. It's about something like 2% of Scottish tribunals. And it seems to me that we have an elephant in the room with this bill, that it puts out of mind the fact that the vast bulk of tribunals remain in the reserved tribunals system. We have about 4,000 cases a year going into the proposed system, more or less. We have something like 60,000 cases a year going through the social entitlement chamber, about 20,000 a year going through Scottish employment tribunals, 10,000 through immigration and asylum, and so on. And when one then looks at the complexity and length of these, one sees that indeed the percentage in this system shifts. So when we talk about characteristics that might emphasise or reduce distinctions between tribunals and courts, we have to bear in mind that we're dealing here with a very small fringe of the system in the short term. And it seems to me that it's therefore important that the bill should go further in a direction of creating a structure that is capable of taking over at least some parts of that remaining 98%. The bill, for example, emphasises that people who the ordinary citizen would call judges sitting in a mental health tribunal, they're called judges in the UK system, are not to be called that, apparently to emphasise some sort of sheep and goats distinction between true judges who sit in Scottish courts and the hoi polloi who sit in tribunals and really aren't up to scratch. And one problem that I see...
I think,
yes.
Mr. Gamble.
And but the UK system has not fallen into that trap, and I think at some points there has been a failure to learn that one of the great... It seems to me from outside, Alan Gamble may speak more about it, one of the great merits of the UK system has been the extent to which it's recognised that one can transfer lessons in both directions. It's often said that a distinction of tribunals is that they're user-friendly and that they have overriding objectives, which, if true, is a very depressing verdict upon Scottish courts, that we have to have tribunals to be user-friendly. An absence in this bill, I think, is any recognition that the new tribunal system ought to be capable of sending messages through to the rest of the judicial system. It's very much a system, it seems to us here in this bill, of old-fashioned democratic centralism. You have a system that goes up the Lord President, he nominates then a judge of his choice who runs it. And you see that in some, perhaps one of the most striking to extraordinary provisions in this that a number of people have commented on is the power of a president of tribunals to lay down completely on his or her own decision what the law is, and just to tell tribunals there is an issue of statutory interpretation as to section X of the Y Act. I am telling you that this is what the right interpretation is. And if you hear submissions that convince you to the contrary, that's tough. Ignore them. And I think that you have to get back, I think, in this bill into something that doesn't so much emphasise distinctions between tribunals and courts, but recognises the modern status of the tribunal system as it's developed, as shown by Mr. Gamble's tribunal, perhaps more than any other.
Thank you. Mr. Gamble.
Yes, thank you, Convener. I would broadly support what Mr. Mitchell has said. In our evidence, if we can deal with a technical point first, as indeed I think the Lord President also agrees, we are really concerned about clause 68.5, which is the one Mr. Mitchell was alluding to, that confers on the senior president or equivalent in Scotland the power, if I recollect, to include points of law in a practice direction. We feel that's really quite inappropriate for the reasons we've given in our written evidence, and I endorse all that Mr. Mitchell has said about that. The directions may include matters relating to the application or interpretation of the law. And Mr. Mitchell has very vividly put what could be the potential effect of that a point of law might conceivably arise where submissions are made to a tribunal judge. And even though they may feel that the law is X, if the senior president has, by invocation of this power, declared it to be Y, they have to say it's Y. I think really the interpretation of the law should be for a tribunal or a court and not for a senior judge acting administratively and not judicially. So I would strongly endorse what Mr. Mitchell has said in that regard.
So you would suggest... Before you come in, Mr. Ward, did you want to make comment there? On
yes,
this particular
I think
issue?
just on the last point, first of all, if I perhaps just being just a coal-faced solicitor, if I tell you that yesterday I received a written decision from a sheriff making a finding in one direction in law, And part of my submissions when he heard me were to point out to him that one of his colleagues in the same court had come to the precisely opposite conclusion. Now, I don't complain about that. What do I do if I don't like it? I go to the Sheriff Principal, and at least for that matter, he will determine it. And I think probably that is the right way to go. On the original question, tribunals are different from courts. You only have to go into one to get the feel of the difference. There are, of course, differences among tribunals, and there are indeed differences in the way in which sheriffs may conduct their courts. But there is a difference, and I do think it would be helpful if we're having a bill about tribunal reform to say what a tribunal is.
Elaine, you want to
My brief supplementary really was, were you advising that section 685 should be removed entirely from the bill, or it should be replaced?
Somebody want to answer, Mr. Henderson?
My position on that would be that both in the Scottish Committee and in the Law Society, judicial independence is a precious commodity. We don't want to undermine that at any stage in the process. And if there is scope in 685 for the independence of the judiciary to be undermined by other sections of the judiciary, then that, to my mind, is a bad thing.
Mr. Mitchell.
I don't see any good point in 68(5). Directions may include instruction on the interpretation of the law. If it's guidance as to application or interpretation, I'm not sure that this takes it much further than what judges constantly do, and I wouldn't have thought that 68(5) at that stage had any content. I'm not aware, I'm open to correction, I'm not aware of anything equivalent to this anywhere else in the Scottish or English legal systems.
It certainly doesn't apply in the 2007 Act, which is the model. But the 2007 Act is the legislation that applies to the Great Britain and in some cases United Kingdom tribunals, including the reserve tribunals to which Mr Mitchell referred, operating in Scotland. There is no equivalent power for the senior president of the Great Britain system of tribunals to invoke this, and I would strongly agree with Mr Mitchell and submit that sub-clause 5 should not be part of the bill.
I think you've made... Yes, Mr Ward.
I may have misheard the question, but the concern is 68(5, not the rest of 68.
No, we do understand that, and you've all made your point clear, I think, on that. So, Roderick?
Yeah, I'd just like to deal with the question of the appointment of the President. Perhaps I ought to put on record, actually, as my register of interest as a member of the Faculty of Advocates. Directing it to you, Mr Mitchell, in particular, you've commented on reservations about the suggestion the new structure should have as its President a Senator. But the Lord President has, in his submission, indicated he would propose to nominate Lady Smith to that role. Just for the record, is there any comment you would like to have about that?
I really don't want to get into a personalised debate, and I think it's possibly unfortunate for the purposes of this debate that inevitably a question as to whether there should be a senator is a question as to whether a particular person should be president. Can I generalise this out? I think that there are really two problems here, which are, in a sense, contradictory of each other. Problem number one is what do we want for a system which is as minuscule as what is offered in the short term by this bill? It is tiny. It's the mental health tribunals, additional support needs, and the education committees, a few bits and bobs, with no particular relationship to each other. Now, if that's what we are left with in 5 years, 10 years' time along the line, then this Parliament will have failed in attempting to rationalise the tribunals system. And I can see in that context the purpose of saying that you might want, albeit rather anomalously, we said it's a Rolls Royce for the job, to bring in somebody from the top who can attempt to impose an overall direction on the system. And to have a senator. But it is a bit strange because it is a very small system and it doesn't really call for one. You've noticed the economics of this that were put to the Finance Committee, which are very strange, about how in some magical way to have a senator on a package of over 200,000 a year with pension doing this job magically only costs bringing in a part-time sheriff because you have a series of actings up. It is an expensive way of doing this. There's a very different problem if you look at this in the longer term. Once we have, as I very much hope we will, in 10 years' time, a system in which all the tribunals in Scotland are operating as part of this, the employment tribunals, which have already got a Scottish jurisdiction independent of the English, and the Scottish parts of the UK unified system. Here I think Alan Gamble may differ. Once we have that, which will require many other changes in this bill, then it would seem strange if some of the very senior people in that system are simply barred from applying for the job of being president. I'd commend to you on this the comments of the employment judges in Scotland. And when you look at the signatories of that, bear in mind that the signatories of that are running a Scottish tribunal system which has approximately 5 times as many cases as are in this. And looking at the amount of judicial time put into it, it must be somewhere between 20 and 50 times as much as this bill contemplates. It's a bit strange to then say to them, but you aren't big enough to run this tiny system. We do have it seems to me that there's no particular long-term purpose in saying it must be a senator.
Perhaps I could actually bring in Mr. Gamble on,
yes,
as you've remember just on your point in your submission, and you say obviously it's your view, strongly of the view that the best interest of users in Scotland is that reserved tribunals should remain intact and there should be no devolution of their functions, as they are concerned with the application of British statutes applying throughout the UK. It's better to have the coherence that's created by a unified judicial structure than by splitting it. But, if you can, Scottish courts currently deal with British statutes, so what's the distinction you're making between courts and tribunals?
Yes. Obviously, I'm expressing this as a personal view, and I try not to get involved in any party political issue here. Our position is a little different, I think, from Jonathan Mitchell's in this regard. We take the view that as long as the present devolution settlement or something like it remains in force, that there is some logic in having a reserved administrative structure for subjects that are substantively reserved in terms of the Scotland Act. For example, immigration, taxation, social security, child support, and employment are all reserved subjects by and large. The second argument is that we operate at the moment in a cross-border way, and that's maybe a more telling argument. For example, I can sit in London if asked. My colleagues from London can sit in Edinburgh and do so occasionally. Given that that wouldn't happen, there was a point of Scots common law or of English common law. But in the common statutory system, we think it's quite important that there be cross-border fertilisation. And even in the proposals that are no longer live proposals for devolving the reserved tribunals, there was provision intended to be made for maintaining the cross-border link. We feel the easier way to maintain the cross-border link is to retain essentially the present system. But that's just a personal view I'm putting forward. I respect the view that Mr Mitchell has put forward. I respect, Mr Campbell, your argument that the Scottish courts also deal with reserved as well as devolved business. That's why I think that second argument, that the coherence of common interpretation at upper tribunal level, given that relatively few cases in practice in social security go beyond the upper tribunal, I think there's an argument for the coherence that cross-border working requires.
Taking on board Mr Mitchell's point, though, that if that's the way it's going to pan out, then you're left with a very small number of cases really covered by this bill. Would it be worth going to this effort for the 2% that Mr Mitchell's identified if it doesn't move on?
Mr Campbell, frankly, again, that's a political, not necessarily a party political, but it's a Westminster stroke Holyrood issue. The Lord Chancellor has announced that the UK government's position is that for the immediate future there will not be devolution of the reserved tribunals in Scotland. That's just a statement of fact. You may well disagree with it, but it's a statement of fact. I mean, one thing that we do what
I think we can just deem that as being political. I think it's a fair point to make whether we need, as it were, a hammer to crack a walnut. If this is not, is it necessary? I think really was the point that Roderick was just making. Do you think this bill's necessary?
Well, I think it's necessary for the reason that Mr Mitchell has advanced. Number one, it gives coherence to what is there already. And secondly, if it should be decided at some point that there be a change and that the reserve tribunals will, to a degree at least, be devolved to Scotland, then this is a ready-made system in which it could be slotted in. And we have no objection to that description. Our personal position is we would prefer that not to happen, at least immediately, but there is a structure here which it could be fitted in the event that it was decided by ministers in London and in Edinburgh that a change be made in that regard.
Yes, to Henderson first, if you don't mind, Mr Mitchell. Yes, Mr Henderson.
The question is it necessary, if all you're going to have is 3% of the tribunal work? Then, if you look at it on the economic level, then plainly the answer is no. If you ask the question differently and say, do you want a Scottish legal system? Do you want a Scottish civil justice system? Which, after all, there is in part. If you want that, then you cannot leave the fragmentation that we have and the chaotic structure of tribunals, where the bad old days of pre-Franks, pre-Leggett anyway, where departments might think they had ownership. And that, I think, still is the case in Whitehall, where departments think they have ownership of a tribunal. And the only way you emphasise that this is part of a justice system is to put it in the hands of a justice body. Now, if you're talking about what that justice body is, then you've got one in this bill. If you go on to the next question, what are you going to do about the reserved areas? Then it is a strange arrangement that we have at present, where an undertaking is given in 2010 that there will be a consultation by the end of 2010 on the devolution of responsibility for, not for the substantive areas of law, but for the administration of justice aspects. And three years later, we're still waiting. Now, it is easily explicable why we're still waiting, but if you look at it in the terms of the context of what is a justice system, it would be a nonsense for there to be a long-term position in Scotland in which some of the justice system was not the responsibility of those who have the majority of the justice system within their control. And that's not, I emphasise, a political argument.
No, I think we're talking about administration here. Yes. Mr Mitchell.
I wanted to point you on this to the most recent report of the UK Senior President of Tribunals and the comments which you'll see on this. I don't want to read it at length, but pages 65 to 66, in which it's pointed out that we've been waiting years for a consultation document on what's to happen with the reserved tribunals in Scotland. I quote, "The governance arrangements for reserved tribunals operating in Scotland might be described as less than ideal," which is language we can all, I think, read. At some point in a not too distant future, it will become necessary to review whether these arrangements remain appropriate. This is a problem that's been shelved. It's not been put aside. And in reality, whatever next year's vote, we're going to be back to this question in 2016. Therefore, it is critical in this bill to have a system which is capable of being presented to members of UK tribunals and their users as one which they can come into, as opposed to one in which, for example, people like Mr Gamble are told, if you shift over, you're going to lose your job, you'll be put on a short-term contract.
Sorry, what do you mean shift over?
Because the current system in the bill provides for no permanent judges. Yes. They're not judges at all. They're simply people who are brought in on contract for short periods.
Can I just elaborate on that? I mean, having expressed a personal view, my stronger point would probably be that if devolution does take place of the reserved tribunals, that steps are taken within that to maintain, and I think this would be possible, something of the, or all indeed, of the cross-border benefits we have currently. That's our major point, and I don't think it's beyond the wit of man to devise a system that could take place in. Can I just endorse Mr Mitchell's point in general? I think it's crucial in this bill there is no provision anywhere for the appointment of a full-time salaried judge in any of the tribunals this bill envisages. First of all, we're going to have these fee-paid judges. I have no problem with that, whatever. But even at the upper tribunal level, it's to be a totally ad hoc tribunal consisting of nominated sheriffs, nominated senators, and a clause that, for obvious personal reasons, I welcome. The judges of the UK tribunal can be nominated on occasion to sit in the Scottish Upper Tribunal. We strongly endorse that and are very thankful indeed that the draftsman has included that in the bill. But the more basic points, one Mr Mitchell has made, we think it's unfortunate there's no provision for any full-time salaried appointment anywhere in this bill.
Does anybody else wish to comment on that? You would agree with that?
I agree with that entirely. I think that, again, if you're trying to set the template for the future, and my understanding is that when this bill was in preparation, it was in preparation in the context of if we weren't going to get something going from Whitehall, then you had to start here sometime. This is it.
Mr Ward.
Just simply for the record, yes, I agree too. I've not joined in because I have nothing useful to add.
No, but nodding heads, it doesn't come up in the OR, so it's quite good to just say, I agree.
That's why I'm telling you, yes, I agree.
Add to this a very practical point from personal experience. I think Mr Mitchell would probably agree with this, and my colleagues from the Law Society, that the standard and quality of justice in tribunals has been vastly enhanced in my submission. And like Mr Mitchell, we've been working in the tribunals field since we were very young men, vastly enhanced by the policy of having full-time salaried judges in employment, in social entitlement and in immigration. And I think everyone who works in these fields would say that the quality has been greatly enhanced, and we'd strongly submit that in any Scottish system that practice be maintained.
I agree. As an outsider, somebody who just comes into the tribunals rather than somebody who sits in them and also comes into the courts, that the truth is that the quality of the tribunal judiciary in Scotland across the board is as high as the quality of the courts judiciary.
And Mr Henderson was nodding and Mr Ward was nodding. I'm just putting that on the record so you don't need to just say.
So that has partly been caused by the increase in the number of full-time salaried judges in the system.
It has.
We would like
coming
to
in
put
on that
Madam
before
Convener,
I wanted to broaden it out, obviously.
If it's about salaries and permanent, you go on, but I've got Sandra with another question. Come in again with a different one, Sandra. You've been very patient.
Thank you very much. I've been very patient and listening to the evidence that's been given. It seems entirely different from your submissions, where basically in particular, you know, Mr Henderson welcomes the bill and you say you provide more coherent and more consistent structure, and that's been throughout all the evidence sessions that we have taken. And then we hear, obviously, quite rightly, the concerns, but the evidence from today is basically, I feel I got, or perhaps members of the public, because I was always an impression it was to give the best service to people who use tribunals, not necessarily for judges and faculties of advocates or whatever it may be. And I may be saying this wrongly, and I'm sure you'll correct me if I am. But can you tell me then, and I know you've mentioned about the salaried judges, courts, etc., but whilst you welcome it, why are you so critical of the different movements towards changing? You welcome it, you say this is a better way, it has to be looked at, it has to be more coherent. And may I say, as someone who has been at immigration cases, supporting asylum seekers, etc., the way we perceive asylum seekers in Scotland is entirely different, the way they're perceived in England. So I would like to see that power brought here to Scotland, and that's a personal opinion. I'll just say, Mr Gamble, I think perhaps you may have been one of the judges. It was in one of the tribunals. Never sat in
an immigration case in my life.
Must be someone that looks
must
a bit
someone
like
else.
My
jurisdiction is social entitlement, or appeals from social entitlement, and as it happens, I also sit as a convener in mental health. But immigration, I've never had any experience.
I apologise.
No
it's
problem.
a very interesting tribunal to sit through and listen. But I would just like a wee bit of clarification from you. Exactly. I know you've said about page 65, 60, section 5 and various other issues, but do you think on the whole this is a good bill to go forward? And depending on what obviously would be the result in 2014, you seem to imply that we need to look at this in a UK context as well.
It's a curate's egg of a bill. The basic idea is good.
Yeah.
The way forward is correct. Yeah. A number of the details are wrong, and some of them very damagingly wrong, like the 68 Clause 68.5 provision, and also some of the others, like the restriction on the right of appeal in so-called second appeals, which we flagged up and nobody else did, because, as always, there is what one might think of as a rather unholy alliance between the judiciary and civil service and administration to cut down on citizens' rights of appeal. But it is fundamentally the right way to go. And I think that our problem with it, in a way, is it doesn't go far enough. It is not a radical enough bill. It does not, for example, attempt to provide for a full-time judiciary in the tribunals, because it is taking a very tepid attitude to what we have at present and saying all we have at present is people who drop in and out for a day here and a week there. Therefore, that's all the bill should provide for. We could do this better. But if the straightforward choice was, do we have this bill as it stands on the statute book or not, then that becomes a difficult question, because it does have a series of flaws. But it is the right way to go. I've no doubt, faculty has no doubt about that.
But of course, this won't be the bill that we debate at the end of the day. We have another 2 stages to go. Yes. So what's helpful to the committee, and you've listed some things just now, is improvements to the bill, either by deletion, amendment, substitution. That's really very useful to us when we're writing our stage 1 report. So feel free.
It's all curable. I mean, the problems in this, none of them are fundamental problems. It is a fundamentally good bill which has a series of significant flaws.
Some of which you've mentioned, but have you? Are there too many to mention on the spot? Or
one which I just mentioned because nobody else giving evidence did is the restriction on rights of appeal to the courts. At clause 42, firstly, you have the general right of appeal to the Court of Session. Sorry, 43. 43.4. Correctly, it is done with a sift that leave has to be given for the appeal, and can only be given if the court or the tribunal is satisfied that this is an arguable appeal. That's the traditional test in Scotland for allowing leave to appeal, and nobody in during the last 100 years or so that it's been operating has really ever had any problems with it in Scotland. Now, there has been a different problem in England, because for whatever reason, the English courts, since World War II, have been flooded with hopeless appeals, commonly run by party litigants, also by lawyers of a class which we don't really have so much of in Scotland. And one sees, for example, that the ratio of appeals against most of
the line lawyers of such a class as we do have in Scotland.
Well, we have
I think we'll not develop that one.
But one sees that there have been continual problems in the English system about being flooded with hopeless cases in which clients are told or tell themselves, I'm going to take this all the way. Now, there's no equivalent problem in Scotland. There never has been. And in that context, it is then strange, I think, to see that we have imposed in clause 45 4 language which was lifted from what has been in England a useful protective measure against this. Now, to be clear on this, although it says a second appeal, what this means is that if I win my case at first tier, it goes to the upper tribunal, and the upper tribunal says the first tier got it wrong, I cannot appeal to the Court of Session unless there's a point of principle. So, from my point of view, this is my first appeal. I've actually held the judgment until that stage, but nevertheless, I'm told there's no important issue of principle here. It's just one of those things. And we do see this as wrong. And it's striking that the only reason why it is there is that there has been a recognised need in England to hold the line against vexatious and frivolous appeals. And it's then lifted in without thinking into our system.
Are there any other points? Yes, I'll take Mr. Ward next.
Yes, Convener, if you're widening this out into general points of concern on the bill, there's one we've not touched on yet, and it is one which is of considerable concern to the Law Society, and that is, it is clear in our submission, I think, that we believe that the Mental Health Tribunal should, by statute, be in a chamber of its own. There has been debate about this. We have at the moment a provision that changes that there is an intention for it to be in a chamber of its own, and the provisions provide that affirmative resolution would be required to alter that. Nevertheless, for constitutional, human rights reasons and in terms of the perceptions of those using that jurisdiction, we still believe and we still adhere to the view that the fact that the Mental Health Tribunal should be in a chamber of its own should be enshrined in statute and thus alterable by you, the Parliament, and not by primary legislation and not by any other route. Now, the Minister has courteously consulted on this. She has explained her position. She's met with my Vice Convener and me. But we must remember that the Mental Health Tribunal was created by primary legislation of this Parliament following a massive amount of consultation. It is bedded in now. It had a few uncertain stages. It is bedded in now. It is working well. Although it may be tiny in terms of number of cases, it is major in its impact and what it has in its jurisdiction, depriving people of their liberty, imposing treatments upon them which they don't want to accept, imposing conditions as to how they may live if they're not actually deprived of their liberty completely. So there are major issues there. The constitutional point is that the Parliament, by primary legislation, created that jurisdiction. It is right that any change should be by the Parliament. Human rights issue is that the parties before the Mental Health Tribunal are usually essentially the state and the patient. And in terms of separation of powers, it is one thing for you as a legislature to set that up and to have the power to change it, which of course you have. It is quite different in fact and in perception if what we have is secondary legislation proposed by ministers and simply laid before the Parliament. In terms of perception, there was great concern just under 5 years ago when a significant change in the status of the Mental Welfare Commission almost slipped through in the context of the Public Services Reform Bill. Caused great concern. And I can say that for the users of services out there, that was an issue, and it would be a very positive message if the Parliament said, we will keep hold of any change in this tribunal we've created. It will be a negative message if there is any erosion of that. So for all of those reasons, we adhere to the view that the Mental Health Tribunal should be in a chamber of its own, should appear on the face of this bill when enacted, and that any change should therefore be for the Parliament. What has not been put to us is, to my mind, any persuasive reason for not doing it that way. It seems to me that if some new jurisdiction were to be created, which could possibly be paired with the Mental Health Tribunal, or if some existing jurisdiction were to be shifted from elsewhere, that almost certainly would be something which would require primary legislation anyway. So we don't see a great disadvantage, other than perhaps a perception of tidiness, in enshrining this in the bill. So we do remain firmly of that. I would stress we are drawing that point to your attention as the legislature. We're not having an argument here with the executive. We're suggesting that you, as the legislature, should keep control of that.
No, it's fine. This is what the committee is for, is to take these views and to ponder them when we draft and to bring to the attention, as you know, to the government and the Parliament at large, any concerns that the committee may have with specific aspects of the bill, and at the end of the day, whether or not they commend it goes further to stage 2. That's the job just now, is to tease out the problems that may arise. Does anybody dispute that? You don't have to come in. Do you feel the same? Does the panel feel the same about mental health issues, mental welfare health issues?
Yes, I personally entirely agree with what Mr Ward has said. Speaking as a convener of mental health, I think the points he's made are very telling. Can I just respond briefly to Mrs White? I entirely endorse what you said. I think the user should be at the heart of this. And although we've got into quite a lot of technical matters this morning, I think you can take it that we're all really concerned about the user. And in particular, the point we were all making, I think, about the importance of having full-time salaried judges is so that the quality of justice for the user would be enhanced. It's for that reason we're emphasising it, not to get jobs for the voice for the legal profession. You know, quite honestly, I mean, quite sincere in saying that. It's the interest of the user is why we're stressing the need for full-time judges.
I understood that
yes.
it would, your position was to do with quality and experience and expertise. Does anybody, I don't have to comment on mental... Yes, Mr. Henderson.
I want to comment to back that point, because and this I'm talking both for the Law Society and also for the now defunct Scottish Committee, established in the wake of the Leggett report, which set the user at the centre and the user's interest. I didn't say that in the Act which founded the AJTC, but that was the way in which the AJTC looked at these things. And absolutely the user has to be at the centre of consideration. Your original question was, do we really welcome the bill? Yes, you start with... what the original question was, thank you for reminding me. I read a wee note of it here. Do we really welcome the bill? Yes, we really do welcome the bill. But to think that you're going to get it right first time, and I'm not just quoting that because that's an HATC report, to think you're going to get it right first time is probably the wrong approach. This is a first step. And I referred earlier to the other components which don't directly relate to this bill, except you have to put this bill in the context of what else is going to be happening.
I think the committee is well aware of the range of quite radical bills that are coming before us to civil justice, criminal justice bill, witnesses, victims and witnesses bill, all interlocking. I mean, we are aware, and it's a difficult one at times to put together. Can I just now I'll take Alison next, because Roderick, you've been in before. So Alison.
It's okay, Convener. I wanted to explore concerns around the mental health tribunal, but Mr Ward's very eloquently kind of preempted that question, and I've heard enough on that. Thank you.
Thank you, Rod. Oh, yes, of course.
A point on that, but which, again, do we welcome it? Yes. The but is this, that somebody used the word fragmentation. We're addressing the consequences of fragmentation, but we have to balance that against the fact that, certainly in the case of the Mental Health Tribunal, a great deal of advantage is derived from the specialisation. And it's balancing these two factors. In terms of the Mental Health Tribunal, both the tribunal and the staff supporting them have built up this specialist knowledge. Somebody in distress can pick up the phone and get a sensible answer. And again, back to the user, that is hugely valuable and important. So the answer is yes, but safeguard what is valuable that we have already.
If I may say, I think the committee really is of the view we accept the specialisation across the various tribunals and indeed the fragmentation argument, but why there's some cohesive legislation required. It's not perfect at this stage, but we hope it's better at stage 3 if we get there. Can I take Roderick, please?
Yes, I've got a couple of questions. Firstly, in relation to procedural rules. We heard last week from one or two witnesses concerns about kind of the fact that there wouldn't be any early movement in terms of creating a body of rules, and we know that the Scottish Civil Justice Council will be giving priority to rules for the courts. Faculty have said it's constitutionally not terribly helpful, undesirable to have Scottish Government interfering in terms of making rules for the tribunals, but given that probably the limited number of tribunals affected, leaving that constitutional issue aside, in practical terms, if we're largely working on the basis of the procedural rules as they are at the moment, how much difficulty is that likely to cause until such times as the Civil Justice Council looks at this properly?
Difficulty is the upper tribunal, isn't it? Because I can see how you have codes, you have sets of rules at the moment for the Mental Health Tribunal, and you could translate that to the Chamber and for the ASNTS. Some of them don't, like education committees, but the gaping hole is the upper tribunal, and that has to be written. Now, this is the more politically sensitive part too, of course, because the upper tribunal tends to deal with the cases which are actually of some more general significance. I think it may be unavoidable that this can't be dealt with top of the queue in the Civil Justice Council, so that there is nobody who can put forward rules but government. But it is a little bit too much in some ways of a theme, and I don't think it's just a constitutional frolic of the faculty to say it matters. It is undesirable that government should be in a position to run so much of this. Take fees, for example. Clause 70 permits the Scottish Government to say that if the Lord President agrees that it will be a good revenue-raising measure to say to anyone in Carstairs who is looking to bring an appeal, you've got to come up with £100. It allows fees across the board without primary legislation. That, it seems to me, is just too much power to give a government without parliamentary control.
Is there anything the legal profession can do to perhaps help the government with this little difficulty they have in the short term?
In what sense?
Well, you talk about ad hoc committees of tribunal judges, just saying that this is a problem, so how do we get around this problem? Really, that's what I'm saying, isn't it?
Well, one thing, again, that's missing in the bill is provision for users groups, which are typically done without statutory formation. They work well in some courts and tribunals. They don't in others. I don't think it really works at all, for example, in Scotland in immigration and asylum. It works after a fashion, perhaps. It works very well in employment. It works fairly well in the Court of Session, and so on. It depends on the body. But I think one thing that would help on this is if there was more attention given to the concept of users groups that could actually drive from a user's point of view. And by users, I wrap up here citizens and legal representatives together, people who use the body, that could put forward proposals for rules.
We have no answer, Madam Convener, but obviously the main problem is going to be that the Scottish Upper Tribunal will be starting from scratch, and it will have to have new rules, whatever happens to the rules for the tribunals that are transferred over. And I have no answer, but I think it's a genuine problem. I think priority should be given to the drafting of these rules.
Comments on procedural rules. Perhaps I move on to the review provisions. And the fact that you've obviously welcomed the proposed provisions at section 38 that say they're incomplete. How would you extend those review provisions? And
I can answer that first, Mr. Campbell. We actually have a concern, frankly, in the opposite direction. We are unhappy with the proposals in clause 38.3. Sorry to be so technical. No, sorry, it's not 38.3, it's further down. It's 39.2b. Sorry to be so precise. 2b. E. Yes. This is the rather odd provision, as we see it, that enables the first-tier tribunal to refer a case. Now, this would mean it wouldn't be an appeal on point of law to the upper tribunal. It would be a referral of the whole case, facts and law. Now, it's our submission that, point one, this does exist in the 07 Act. It's not been used very often. It's never been used in Scotland so far in the 5 years since the 07 Act has been operating. Our point of principle is the upper tribunal is not really set up to hear witnesses and examine witnesses and make findings of fact. Our role is really more to determine what the law is and, if need be, remit to the first tier to have another go at finding the facts. We don't think this provision is necessary. I know it's in the 07 Act. It's not been very much used there, and we feel it's an unnecessary complication, this power to refer the whole case, facts and law, that's vested in the first tier tribunal. We would prefer it not to be there.
Anyone else wish to comment on that particular comment?
Clause 38 doesn't actually articulate at all the circumstances in which there might be a review, and got an uneasy feeling that what this allows, let's say I'm a first-tier tribunal judge, I make a decision, tell the parties what my decision is. They go away thinking they've got that under the belt. I sleep on it. I think about it. I think about it again, and I come back the following week and just say I'm reviewing that because I got it wrong. I think you've got to articulate what it is that leads to a review. There's a clear need in practice for what's sometimes called a slip rule, where I've issued a decision which is just contained a typo, an arithmetical error, things like that, and courts do that. Mm-hmm. Beyond that, I think it becomes quite difficult. I mean, there's no doubt that there are policy arguments for saying if I do think about it and come back a week later, my second thoughts may be better than my first. I doubt it. But at the moment, it's just open-ended.
I think that as far as if you're looking at tribunals as different from courts, and you're looking at something which is more flexible, is more responsive, and therefore may very well be different in the way in which it actually is portrayed. And the idea that you can review may be novel, it may be unwelcome, but it allows for the mistake to be rectified. And I think that that's probably quite a valuable thing from the user point of view. Yes, all right, you're sacrificing some certainty to it, but if you're talking about disputes, if we're talking about in the reserved area, disputes in the state-citizen context, then a mistake against a citizen in favour of the state is a slightly different context to a mistake, as it were, in a citizen-citizen competition.
Is the problem the use of the word matter? I don't know, I'm asking.
We have no objection to the review provision as such, though I do agree with Mr Mitchell that it should be spelled out more clearly what the grounds for it should be. Our concern, in my answer to Mr Campbell, is a more specific one, which is one of the remedies that follow after review, which is to refer it, the whole thing, holus bolus, to the upper tribunal. We feel it's unlikely to be used and is unnecessary, and retaining the simple right of appeal to the upper tribunal is a better remedy. I have no objection to the idea of a review, provided the grounds for it are spelled out. It's one of the specific remedies. Sorry we have to descend into this technicality, but I guess that's what we're here
the law
for.
is all technicalities.
Isn't it? Yeah.
But can I just ask you then, what are you just saying that it's 39 2B should just be deleted?
The relevant parts of 39.3 that follow on from that, for example,
yes,
they may redecide the matter concerned.
Okay.
It's more or less a lift, Madam Convener, from the 07 Act, more or less, for the UK tribunals. It's not been used very much, and I don't think it's a very suitable remedy.
Henderson.
Well, the key there maybe it's not been used very much. If it's been used at all, and if it's not going to be used, well, leave it. If it's going to be used, it's probably going to be used in circumstances which are relevant. If they're not, I should think the tribunal will see it off. I mean, I would leave it.
Yeah, I thought so. You say not very much, but it has been used.
With respect, Mr Henderson, the situation that Mr Mitchell...
I love words with respect. You get lawyers involved. Yeah. Just go for it.
The phrase that the example that Mr Mitchell has given has actually happened in the first tier. Although we didn't consider the application was competent, but a tribunal judge completely rewrote her decision, then reviewed it, set it aside, and had tried to send it all up to us to start afresh. So it can happen under these provisions. As it happened for technical reasons, we dealt with it another way. But that danger was there. Having made a decision, 2 or 3 days later, she rewrote it and purported to refer the case.
I've seen this too. Just differing, however, from Mr Campbell, I agree with him and everything else there. Personally, I think there is merit in allowing a first-tier tribunal to refer something up to the upper tribunal for a definitive judgment. And a very recent topical example is the decisions at Fife last week of the first-tier tribunal, what is a bedroom, for purposes of bedroom tax, which have been, I think, quite widely circulated. Now, without in any way criticising what's in it, these are matters of general importance, which really ought to be decided authoritatively, whether the cupboard can be a bedroom, that sort of thing. And I think there are difficulties in restricting this to appeals, which can only be on points of law, where you ultimately may end up with a spread of very different first instance fact decisions, when it would have been helpful to everybody to get a general definitive view from above.
Yes, that's fine. I think we've teased that, but it's on a matter the committee will again consider. Elaine?
It was on the Lands Tribunal of Scotland. I think the Law Society and indeed the Land Tribunal argued that it too should be in a separate chamber, and it was working fairly well as it is. I just wondered whether you thought that ought also to be on the face of the legislation.
Well, that's certainly the view of the Lands Tribunal, expressed pretty forcefully, I think, last week, and it's a view that the Law Society would certainly not dissent from. I think that, again, the problem that the committee and the Parliament will grapple with is if you're setting up something and everybody says, I want out, it's a wee bit potentially chaotic. So yes, the nature of that jurisdiction is such that it probably should be on its own. Whether or not it comes out completely, which I think maybe the Lord President's view is, and we'll just deal with things as they are. I think that's going probably too far. The job is to try to create a structure into which you can accommodate those existing structures and processes which have similarities and which you want to emphasise the similarities and develop them. You try to cluster them together. Internally, is it to be in this chamber or that chamber becomes, I think, sorry about this, arguing amongst ourselves, a secondary issue, although where we are just now, clearly mental health, the nature of mental health, takes it into a completely different realm. And that is one of the subjects you were talking about earlier, the judicial title. Clearly, different considerations are coming into play when you're talking about the mental health jurisdiction to other jurisdictions. And you've got to try and create a structure which is going to be able to accommodate this vast spectrum of differences. Didn't answer your question, probably.
I think you did, sort of. I mean, you're saying that I think what I was taking from it is obviously talking about mental health issues, it's loss of liberty and so on. It's a far bigger dynamic than just a different kind of more court process of the Lands Tribunal. There's huge flexibility across processes in all different tribunals. Was that correct? I know to summarise incorrectly. I'll let you back in after Mr Campbell.
I have no views on this at all, really. The 07 Act put the English Lands Tribunal into the upper tribunal. The jurisdiction of the Lands Tribunal in England and Wales is part of the upper tribunal. That's a sort of compromise, I guess. We've been keeping it out altogether and making it part of the general tribunal structure. For what it's worth, that's what the 07 Act did.
Thank you. Mr Ward.
There may have been some debate about whether the Lands Tribunal should be in the exercise at all. I want to make it clear the Law Society's position is that the Mental Health Tribunal, yes, it should be within the exercise. How should it stand within it? Yes. I just want to re-emphasise that point.
Right. Here I go with this. Oh, no, I just about said no more questions, John, but there you are. Sneaking up on me.
Thank you very much, Convener. I think most of what the panel have raised today has probably been more of technical and academic issues. And, you know, as a committee, I think our concern is what the end result will be for the general public. Do you believe that when the new bill is going through the Parliament, and whenever that bill is finalised, that there will be significant benefits to the public, or do you find that, or do you perhaps think that perhaps we're improving the service to one of further confusion?
Bill, as it stands, then no, there aren't major advantages to the public. There's some minor advantages, little bits and pieces, but to be honest, it's not really going to matter very much. It wouldn't justify the effort being spent on it. Whether there are benefits to the public is in a really radical rethinking of the whole setup. And that we have had, I think. We can see how it's happened in the UK system.
I suppose the major benefit of this is that Cinderella is at last going to go to the ball. Tribunals are going to become part of something.
That to me, I got quite lost to see talk about mental health issues as Cinderella or whatever. You know, I'm not good at metaphors at this time of the day. Anyway.
Cinderella is traditionally the title used to describe administrative justice. Absolutely.
You learn something every day.
I learn something every day. And that's good. So this is actually the first time that we've, and I know that this bill goes way beyond, potentially way beyond administrative justice. Into party stuff. But at the first time that anybody has actually looked at creating a coherent and integrated structure for part of the civil justice in Scotland, that's not going to be a big deal as far as most individuals in the street are concerned, but they will see the benefits of that as you begin to develop the tribunals over the coming 10 years.
Mr Ward.
Briefly, my comments as regarding the Mental Health Tribunal were mainly designed to avoid the users and the public seeing things not working so well. But on the more general point, I think it is relevant to consider where you as a Parliament, for some reason, sometime in the future, are creating a new jurisdiction. Where do you put it? How do you put it? Do you have a ready-made berth for a new jurisdiction, which will work from day one? And will it be clear to you on the original definition point we're discussing, yes, what we're creating is something which ought to go to a tribunal? And I think there are advantages there for the future.
And I think the point is that many of the public, or more of the public, will be involved at some time in their life with some kind of tribunal or appeals committee or something than they will with ever any civil court. And that's terribly important to recognise this as well.
Right now, people who get themselves before tribunals also, because of their circumstances, will find themselves before several tribunals in quick succession of different sorts. And if the rules of the game are different every time they go along to a tribunal, that is not helpful.
Mr Gamble.
I make one point in answer to Mr Pentland. Broadly speaking, I agree with what Mr Mitchell has said, that the changes are, although perhaps important, are not going to make an awful lot of difference to the man in the street. But one can I just highlight, I think on the whole it is better that appeals from first-tier tribunals go to the upper tribunal and not to the courts. And one effect of this bill, of course, is just exactly that appeals from the first-tier tribunal, as with the Great Britain tribunals, now go to the upper tribunal and not to the court. Now, the upper tribunal is a bit more formal than the first-tier tribunal, but it's considerably less formal than particularly the Court of Session. English experience suggests that the effect of that will be that the number of cases taken in appeal from the first-tier tribunal will increase because it's a less expensive, more flexible, more informal appeal process. So I hope we don't think it's special pleading, but I would argue that that change is one that will be for the benefit of the user.
Yes.
John Finney, is this a short one, is it? Excellent.
Yeah, thank you. It's a question, Convener, to Mr Mitchell with regard to the faculty's submission in relation to Section 30, assignment policy, and particularly the term cross-ticketing. I wonder if you could comment on that, particularly the suggestion that I know that you would seek the preservation of right of tribunal members to be appointed between tribunals and chambers, and the cost of training associated with that, please.
Yes, on cross-ticketing, I think one wants to bear in mind that these are all expert bodies. They're all each of these chambers is specialist and expert in a manner in which traditionally Scottish courts have not been. A sheriff court is a court of, in effect, almost universal jurisdiction. There's always, I think, a tension here between the users and the judicial requirement to have proper specialists, for example, hearing mental health cases, and the administrative pressure, in particular on cost grounds, to say it's so much cheaper if you can just cross-ticket. Now, you look at the way in which here, for example, there is a provision for effectively open-ended cross-ticketing of people coming in as sheriffs. It's strange in a number of ways, but if you ask yourself, what does it really mean in practice? What it means is that if there's a mental health tribunal, in fact, if there's any tribunal at all, that is going to take place next week, and then the so-called legal member, the judge, has got chicken pox, that there can then just be a phone call off to find out if there's some part-time sheriff who can be parachuted in. That's wrong, it's not a part-time sheriff, full-time sheriff who'd be coming in part-time into this tribunal, who can be parachuted in on the basis that simply by virtue of being a sheriff, they have that expertise. Now, I've no objection, none of us have any objection in principle to cross-ticketing. Somebody can have more than one expertise, but it has to be kept under control.
Yes. Do you accept there's a difference between expertise and training? Because everyone has to start somewhere, and presumably, you know, all the people who have gained that expertise had their first day sitting.
Oh, yes. Well, absolutely, and of course, even people now who start as Court of Session judges are, in effect, trained on a job for the first 6 months.
What I want to ask, because is there something that we haven't asked about the bill as it sits at the moment. You've gone to various sections, you've mentioned some issues, you've talked about the general policies, the mental health issue. Is there anything we haven't asked about that we should have asked that you've been? Thank you very much. There isn't, Mr Gamble. Now,
Thank you for all your questions and your obvious research and whatever into the contents of the bill. Yeah, thank you very much.
Mr Mitchell, is there anything you want to add, any section you want us to look at, or any issue that hasn't been touched on?
No, not of substance. I do want to stress that I think that this is a fundamentally good bill. Yes. It is going the right way, and we have been addressing the problems and the complaints with it, and that is really just because I think we all take for granted that this is the right way forward.
Yes.
Thank you. Mr Henderson.
Well, I think that it's a welcome bill. Yes, there are glitches in it here and there, but in general terms, it's a bill to be welcomed.
Thank you very much, Mr Warden.
Yes, I hope you've realised that we are not nitpicking because we don't like it.
We want nitpicking.
We are trying hard to help you get it right because it should
That's
happen.
right. We don't mind nitpicking. That's what we're
I'm saying the motive. People can try and destroy something because they don't want to see it happening.
No, I understood that.
I think certainly from the Law Society point of view, we want to see it happening, but we want to help you get it right.
That's what we want to hear. Thank you very much. And that ends this evidence session. Thank you. Now that concludes this. Thank you. I've already said our next meeting is 17th September. We'll hear from the Lord President, Minister for Community Safety and Legal Affairs on this bill, and I therefore close this meeting. Thank you. Let's stay put.